But several subsequent submissions by the government persuade the court that the risk posed to the employees who were on leave while abroad, if there is any, right, the judge admits, is far more minimal than it initially appeared. You're kidding, judge. It was over-exaggerated and you bought it, and now you have to walk that back? That's bad judgment. The court will accordingly deny the union's motion for a preliminary injunction and will dissolve its previously issued temporary restraining order. Boom. The Trump administration wins a big one. You can see this case came down out of the court of Judge Carl J. Nichols, District of Columbia, judge that Trump appointed in the case brought against the administration from the American Foreign Service and other entities suing Trump to stop all the USAID cuts. Remember, Trump said it's all getting eliminated. It's going bye-bye. I'm the president. I have the power over foreign affairs. We're in control of the State Department. Cuts happened quickly. They sued, and what's interesting about this, we have a very good ruling that just came out today, but this judge, Judge Carl J. Nichols, who was terrible on the January 6 cases, granted the people who sued Trump, we'll call them the unions, the American Foreign Service Union, so the USAID people, they got a TRO, a temporary restraining order. And this judge granted it pretty unequivocally and ordered, if you remember this, back on February 13th, ordered that no USAID employees shall be evacuated and that Trump is basically stopped from doing anything related to this, saying all administrative leave, all USAID employees currently placed on administrative leave shall be reinstated, shall be given access to their emails and their security. No USAID employees shall be evacuated before the 14th and more. Then he extended it. So it was pretty, wow. Trump came in, gave this order, and the judge just reversed it. We're all scratching our heads here going, Judge, that's a pretty horrific thing to do since you're not the president. And we were disgusted by that order. But then we fast forward, and today, look what we have here. Very curious decision in the case that just came out from Judge Nichols. And he issued a victory for the president. He says, all right, look, the case, of course, is the Foreign Service Association. It's basically a union for the USAID people who all got fired. They're all upset. You can't fire us. We did. Says here, the original plaintiffs in this lawsuit are two unions that represent the employees of USAID. You can't fire our people. And they challenged Trump's executive orders, saying that there will be a systematic dismantling of the agency. And we're all sitting here going, yeah, we know. That's the point. So those unions initially moved for a TRO back on February 7th. The court granted it in part that very day. And we read it, we're like, what? Judge's like, yeah, you could lose your jobs. We're like, we know, Judge. That's the point. Following full briefing on that, the submission of a bunch of other things, the court now concludes that the unions have not demonstrated that further injunctive relief is warranted. So they're not getting more out of here. Let's see where this goes. Said in the Foreign Assistance Act of 1961, Congress declared that the principal objective of foreign policy is the encouragement and sustained support of the people of developing countries and more. So to implement that, Kennedy that same year issued an executive order. They established USAID. From 1961 until today, they have been tasked by statute, right, by Congress, of assisting strategically important and countries in conflict, leading U.S. efforts to alleviate poverty, disease, and humanitarian need, assisting with commercial interests by supporting developing countries' economic growth and world trade, blah, blah, blah. Which again, you're like, what the hell are we doing any of that for? Until we get that stuff solved in our own country, what were they doing? More than 35 years after USAID was first established as an arm of the State Department, Congress then passed in 1998 the Foreign Affairs Reform Act. That gave the president 60 days where he could submit to Congress a report when he wanted to consolidate and streamline USAID. He's got to notify them. And we're always asking, wait a minute, where did that come into in the Constitution that the president has to do before he executes the law? He's got to notify you. It's not in the Constitution. These are just little strings that Congress attaches. The president executes the law according to his execution of the law. Otherwise, Congress is the president. They get to dictate certain actions. That's not their job to execute anything. But Clinton's report took none of those steps, said that instead determined that USAID will remain a distinct agency with a separate appropriation. So Clinton did something with it. Okay. So to be sure, then Congress, together with Bill Clinton's determination, it did not make USAID wholly independent of the State Department, right? So, because that would be also extra constitutional. That would be not allowed. We don't have a fourth branch of government called the USAID created by statute because Congress wanted to. For example, the judge writes, the FARA places USAID administrator under the direct authority of the Secretary of State. In this case, that would be Rubio. And some kinds of foreign aid are jointly administered by the State Department and USAID. But USAID is nevertheless considered what they quote here an independent establishment, right? Which is such a stupid phrase. It's just like the Patriot Act, right? Was it really patriotic to let our government come in and violate all our constitutional rights? No, but they called it that. Is it really an independent anything? No, it's not, but they call it that. And it gets its own money. Now, the further appropriation Appropriations Act of 2024, for example, appropriates funds specifically for USAID and specific programs and provides that appropriated funds cannot be used to implement a reorganization or redesign of any agency without prior consultation by the head of the agency with the appropriate congressional committees. Again, that's a joke. You have to come check with your little nannies over in Congress before you execute the law? No. That's trying to create a co-presidency where you have to make these decisions. No. If you have a problem with somebody and there's something happening in the executive branch, you have to act with haste and finality. And that's what the executive branch does. That's why it exists. So they can separate it out to actually execute things. Congress can't execute crap. That's why they don't have that responsibility. It's by design. We don't want them to. We don't want them to have a say in that. You pass the laws, and if you don't like how the president is executing it, then you can complain about it, and you can have that back and forth, that ebb and flow with the executive branch. You're allowed to do that. Say, well, he should be doing this, and there are political consequences if he does not. If you really don't like it, you can impeach him. By statute, that consultation must also include a provision of a detailed justification for any proposed action. So here they say, this is the judge writing. The day he took office, Trump issued an executive order eliminating a bunch of stuff. The executive order provides the following. The United States foreign aid industry and bureaucracy are not aligned with American interests, and in many cases are antithetical to American values, and accordingly mandates the immediate 90-day pause. Nothing's canceled. It's a pause on new obligations and disbursements, and he says new here, obligations and disbursements of development assistance funds, pending reviews of the programs for efficiency and consistency with policy. Now, at the end of that period, according to Trump's order, responsible agency and department heads are to make determinations on whether to continue or to modify or cease each foreign assistance program based upon the review recommendations. But the executive order also allows obligations and disbursements to resume before that. If a review is conducted and Secretary of State decides to continue the program in the same or modified form, then they can do it. Now, and it also permits the Secretary of State to completely waive the pause for a certain specific program. So then 4 days later, Trump issues the EO. Rubio comes out, issues a memo. He does it. Boom. Pauses everything. All new obligations of funding are paused. The memo also directs, saying for existing foreign assistance awards, contracting officers and grant officers shall immediately issue stop work orders consistent with the terms under the award, right? So follow the terms of the agreement and get out of it pursuant to the terms of the agreement as you're allowed. Does the contract allow you to get out? Great, get out. If it doesn't, well, you're kind of stuck there. So follow the terms and get out until such time as we shall determine that that other contract comes up for review. But then Secretary Rubio, writes the judge, approved waivers of the pause for foreign financing for Israel and Egypt, and also for emergency food assistance, and also for legitimate expenses incurred prior to the date of the memo, right? For example, they were saying that there was, $500 million of food, like sitting in containers on shipping lanes or whatever. And we can't just let that sit there. So we got to pay for somebody to transport it, to deliver it. Can we do that? Sure, go. It's already sitting there, so we're not going to let good money go bad. Salaries, all of it. For U.S. direct hires, it was all allowed. And Rubio later also waived the pause to life-saving humanitarian assistance during the period of review. Okay, so all of those claims that babies are falling out of skies and dying of Ebola because of our limited and heinous cuts is not true, right? On January 30th, Trump appointed Rubio as the acting administrator of USAID. 4 days later, the secretary sent a letter to members of the foreign affairs committees over in Congress, consistent with the law, says we're going to initiate consultations with you about how we redistribute this money. And a substantial number of these programs did not benefit the American people, as your legislation mandated it did. Didn't reflect the priorities at all. Rubio also said he was delegating these duties to Peter Morocco, who we heard from in his declaration earlier this week. So in order to carry out that review process, but to also prevent noncompliance by USAID employees who were still siphoning out money, they said pencils down, which is a great way to think about that, right? Don't touch anything. Exam is over. Began placing employees on administrative leave. Of the approximately 4,800 direct hire employees of USAID who were stationed both across foreign and domestic posts, 58 of the 4,800 were initially placed on leave. By February 7th, 2140 had been placed on leave. Then they determined that 611 were essential to carry out its statutory functions. This is what we have to have in order to comply with the bureaucrats in the Capitol, and had planned to place the remaining 2,014 employees on paid leave starting Feb 7. So then USAID, right, the government says, it has a careful plan. You're overseas, here's our plan. That's according to Morocco. Namely, those employees will be required to decide within 30 days, do you want to come home or not? Employees who choose to remain abroad will be entitled to all the previous benefits as long as they're on administrative leave. They can do whatever they want as long as they're on leave, but they're probably going to be fired. So, as USAID informed its employees when we announced this earlier, you retain the option to remain at your post, even if you're on leave. And although employees on leave may lose access to certain systems, Morocco attests that they've got no plan to shut them out from overseas security resources when they're overseas. So nobody is being cut out or left out to dry like Obama did in Benghazi. Overseas employees who choose not to return within 30 days will have their travel coordinated and more, as we saw. But the court then made some orders, as we recall. The unions filed their first complaint back in February. They said Trump is violating the Constitution. He can't do this. He's dismantling the USAID without lawful authority to do that. And just before noon the following day, the day on which USAID had intended to place 2,000 people on leave, they moved for a TRO that would stop them from firing these people. In light of the midnight deadline, the court scheduled a hearing late that afternoon and heard it. After the argument, the court entered a limited TRO. Yeah, right. They said don't fire anybody. The court explained in their original TRO that while the union's request was styled as pertaining to the wholesale dissolution of USAID, because they said they're dissolving everything, their allegations of irreparable injury, which is required for a TRO, right? It's one of those four elements that we try to remember. Irreparable injury. It flowed principally from three subsidiary government actions. It wasn't the wholesale dissolution that was harming you. It was these other things. And in their complaint, they said all of USAID was going to go away. But that's not what actually they were saying. He says that what they were actually saying is that some people were on leave, okay, because like it didn't, obviously the whole thing did not get dissolved. So they were just upset about some administrative leave. They were upset about the expedited evacuation of employees, like they had to bring a bunch of people back quickly. And they were upset about the 90-day pause on foreign assistance. They said it was wholesale dissolution, but obviously that's not happening. So it's these things. So he says, okay, well, we therefore concluded, based on the limited record, I mean, everything was happening like at midnight. So this judge is now giving himself an excuse for writing a ridiculous TRO in the first place. It's like, I had no choice. I was so stressed under pressure. He says that they demonstrated that there was entitlement to temporary relief, at least with respect to the first and second arguments, saying there could be irreparable harm. They could lose access to government security, and it could be maybe unlawful that the government was doing this. But the court reached the opposite conclusion, explaining that their allegations that the funding freeze would cause emotional harm, remember that, because that was part of one of their complaints. It was too hypothetical, the judge said. So he kind of split it, issued a TRO, made Trump do certain things. So then the court accordingly ordered the government to reinstate, right, all USAID employees who were already on leave and to withhold from placing anyone else on leave, but it did not stop the funding pause in any way, the original order. Hire them back, but they can look at the funds. Now, the same day, that same order converted their motion into a motion for a preliminary injunction, set a briefing schedule. They came in. Then they issued another TRO, clarified some things, and they tell us what the legal standard is. The judge explains. All right, look, it is well established that when there's an injunction in government personnel cases, they're not orthodox stays. Like, these are a little bit strange. We use TROs all the time, but this is against government employees, so it's a little bit different. Saying the government has traditionally been granted the widest latitude in the dispatch of its own internal affairs, right? The government has a presumption that the government is doing well. If everything that they do is legitimate. Interference by the judicial department could lead to confusion in the management of executive affairs. 1898 case. They figured it out back then. This judge is just learning too. The Supreme Court has thus been clear in considering whether to stop actions that involve federal employment matters. Courts may not routinely apply the normal standards. Instead, they may issue relief only upon a far more rigorous showing of entitlement, not just because these people have emotional damage. Irreparable harm, he says, look, were you guys actually harmed? He just went through and explained, laid some foundation for us. Says because the basis of injunctive relief in federal courts has always been irreparable harm, like they have to show they're going to have irreparable harm, not harm that cannot be repaired at all. It's irreparable. It is helpful to begin the analysis here. Now, the unions, USAID people, they say that Trump's conduct has harmed and will harm them and their members in many ways. But to qualify for irreparable harm, it must be actual, okay, not theoretical. It must be certain. It must be great. The word is irreparable, beyond remediation. There's nothing we can do. Now, upon scrutiny of this, employment-related injuries that they assert are not irreparable because you can get back pay and other damages, nor are they sufficient in kind and degree to override the executive branch here. Duh! First, the unions argue that their members will face irreparable harm. Well, if we're on paid, the judge even notes here, paid administrative leave, like we're going to be harmed. Sitting at home, they're going to lack access to agency email and security, and that could cause safety risks. But he says, as I explained, is already reflected. The court was very concerned about this. That's why I gave you the TRO in the first place. It was actually motivated by that. I thought, man, did the State Department, like all these judges are so spring-loaded to be against Trump. They're like, people are probably dying right now. That's how reckless they are. Like, no, they weren't. Everybody had access to everything they needed. Nobody's falling out of the sky. Calm down. But the judge granted the TRO. I didn't know. But several subsequent submissions by the government persuade the court that the risk posed to the employees who were on leave while abroad, if there is any, right, the judge admits, is far more more minimal than it initially appeared. You're kidding, Judge. It was over-exaggerated and you bought it, and now you have to walk that back. That's bad judgment. In particular, in opposing the motion, the government submitted a declaration from Peter Morocco. Now they say, yeah, although employees are on leave, although they may lose access to certain systems, the pause has no plan or proposal that would shut them out at all from any overseas security resources whatsoever. In a supplemental declaration, Deputy Administrator also attests that overseas employees on leave will continue to fall under the authority of the Chief of Mission, who's already responsible for them. So they're going to be protected throughout all of their missions. Judge says, look, here's all the things they're doing. They get two-way radios, they can communicate, they get the safe alert system, they get messaging, they get USAID issued devices, they get the SCRY, the scary panic, situal awareness button, they can hit a panic button, they got geospatial tracking, diplomatic security responses. They're going to remain subject to everything, like travel, armored vehicle requirements, curfews, all sorts of things. So there's no harm at all, Judge. They were exploiting your sympathy, and you bought it. Based on the record, the court concludes that the prospect of plaintiff's members suffering physical harm is highly unlikely. You're kidding, huh? And to the extent that these unions allege that paid leave will harm their members because they're going to remove security protections, like by tarnishing their reputations or preventing them from doing their jobs, those are the types of standard employment harms that are way reparable. They're not irreparable. It's way short of the irreparable injury standard. Yes, okay, your reputation might be bad because you're not going to be the chief administrator of the Ebola entourage of Africa or whatever. Okay, nobody knows what you do, where the money went, what you actually deliver, if you're just taking portions of that to blog or what. So that's not an irreparable injury. Go find another job. If you were wrongfully fired, go get back damages and you can settle that in a different arena. But the unions also say that their members will be irreparably harmed, but what they described as a mandatory recall notice. Again, the court was concerned that there could be non-financial injuries, like harms to their health care, harms to their children's education, stuff that no future lawsuit could redress. But again, the government's additional submissions have convinced the court that their initial assertions of harm were overstated. We know, Judge. Now, the record now reflects that no USAID employee stationed abroad has been or imminently will be required to return within 30 days. Rather, as things stand, if they're stationed abroad, they have a choice. If they want to come back, they can come back within 30 days. If they don't have to. But they're still eligible for agency-funded travel and return. In fact, they've established a 200-person plus team dedicated to coordinating those trips. And if those employees wish to remain at their post, they can. As long as they're on leave, they get all the benefits. But we're not going to pay for you if you drop out or something, and you might need to pay for an individualized exception depending on timing and other things. Now, this recall scheme, says the judge, does not eliminate the possibility of financial harm. Like, yeah, they might lose some money or something. But as they point out, the unions, some employees may not receive exemptions. They may be required to pay for their own travel back if they choose to stay at the post. But those are money harms. Yeah, like travel expenses, relocation expenses, foreign service workers, all this. That's money. Those are not irreparable. It's just money. They just have to get money back. In the event that they are not reimbursed, well, they can just sue at a later date. Not a problem. To the extent that the unions are concerned their members could in the future be directed to depart or just strip, that's not imminent. So it's not an imminent harm. It could happen. Now, if that is an actual harm, sue us again. Now, instead, as noted, USAID via Trump has expressly informed employees that they retain the option to retain at their posts, even if they're on leave. Therefore, a mitigation of any theoretical future harm. Now, the unions also, the judge is knocking these out one by one. So then they say, well, okay, here's how we're harmed. We're irreparably harmed because the money, funding got cut off and there's stop work orders. This is their big one. Now, the court previously explained in the TRO that limited Trump why their allegations as to the default on foreign aid contracts would financially and emotionally harm their employees, right? Financial harm and emotional harm. The judge is even referencing that multiple times. You guys are such pathetic babies. Grow some big balls. They were too hypothetical to warrant relief. In their reply, then the unions switched their tacks to argue that because of modification and termination of certain contracts may be unlawful, employees directed to make those changes will face irreparable harm because they'll lose the goodwill. All right, so again, theoretical may, and it's what's the harm? It's goodwill. It's not very harmful. You're not like guaranteed entitled to goodwill. But this argument doesn't lead to a new result, even though they changed it without any clarity on the terms of the contracts. Their allegations of illegality from Trump, way too speculative. There is no irreparable harm here. Nor in any event does the court find it likely that a partner agency would attribute a contract modification to any USAID employee in their personal capacity. So if the government cancels the contract, like why does that harm the employee? Not their fault. And the judge says it right here. If you think there's another harm that's coming down the line, renew your motion. Sue it later, but it's got to be clear. So at the February 12th hearing not long ago, the unions said that the funding freeze prevented the union members from paying their living expenses and their utility bills and their tuition bills. But as even your declarants explain, Rubio waived the funding pause for living and operating expenses. He wrote it in your filing. So that's like not true, according to your own evidence. And while Deputy USAID Administrator Morocco also acknowledged that widespread changes at the agencies could have caused delays in certain payments, they're working diligently to address these things. Like your kid's not going to be pulled out of school either. You're going to get living expenses and reimbursements during your leave. So it's so much ado about nothing, isn't it? Every news story has been about people being pulled out of this and cancer treatments going here and the AIDS kids over there and whatever. Navy veterans, as we saw yesterday, it's like nonstop. And it's not that. It's the boy crying wolf again. Trump is doing these bad things. They're very mostly upset about the money. It thus appears that any non-payment was unintentional is going to be resolved, so relax. In fact, with respect to specific instances of delayed payments, the government even attested those bills will be settled in 3 to 5 days, like you're going to get your living money, so calm down. Finally, the unions assert that a number of harms were premised on the notion that beyond being placed on administrative leave, they say they're ultimately going to lose their jobs. Well, they're going to be fired and they're entitled to jobs forever. But many of the harms that would result from such an action, like the unlawful non-payment, would be financial and therefore not irreparable. Like they'll lose their job, go sue for that, get back pay, and damages for wrongful termination. But those harms are obviously not imminent either. They're not a clear and present need for equitable relief. The government has reiterated it's placing them on leave, said that explicitly, for 90 days. It's been 1 month. Calm down. The audit of the agency's spending is what they're doing. And so for these reasons, the judge just took every one of their arguments out one by one. They have not established that their members would suffer imminent irreparable harm as a result of Trump's actions absent a preliminary injunction. So a bunch of crying from them that the judge bought the first time and then undoes it. It says, turning to the likelihood, right, the other element of the TRO and the preliminary injunction, will they succeed? Will the unions win further down the line? He says, well, it may be the case that at a high level of generality and in the long run, their assertions of harm could flow from their constitutional APA, the Administrative Procedures Act, claims about the unlawful dismantling of USAID. But at the present, the agency is still standing. So there hasn't been any harm. The alleged injuries on which they're relying, seeking relief from, is essentially from their members' employment relationships with the agency. Now, as we just explained, the judge says, your complaints about the harms are at bottom archetypal complaints about changed employment conditions and their follow-on effects. Okay, it's all financial. The judges, this is just your standard whining. Yes, there are changes in employment that happen every day in this country. People get fired, they don't form unions and sue the government saying, I'm entitled to a job for the rest of my life and pay me my money. Even plaintiffs' allegations of harm of the broader funding pause are about money and their capacities as employees. Like they have to pay their own living expenses and stuff like that, and their professional goodwill. Well, guess what? Congress has already created other statutory schemes for this. Federal employees, if they have disputes with the federal government, they can use the statutes and the mechanisms that Congress created for those. They can go through the Federal Service Labor Management Relations statutes, the Civil Service Reform Act. All this case law supports it. Under those statutes, labor disputes involving so-called civil servants who sue their own government, that's how much of servants they are. Hey guys, we're broke. We can't pay you anymore. What? Yes, you can. You are paying us because we're civil servants serving society, taking all of our money. Disputes in which the unions are involved are generally adjudicated by an agency outside of the courts. For foreign service workers, they handle it through these statutes. In that system, they go to the grievance board and the National Labor Relations Board, and they can complain there. District courts, of course, generally have jurisdictions over civil actions, but it's already well established. Congress can exclude us from hearing these claims. Here, both considerations indicate that Congress likely intended these unions to be brought exclusively through another remedy, and they should do that. They shouldn't be filing in this court. They're not going to be deprived of any meaningful judicial review. They can bring their claims to the labor boards. Collective bargaining and all those things can be adjudicated there. It's also likely that a domestic USAID employee or representative could object to some of this, but their scheme was established. They define what a grievance is. It's broad. It would permit them, and a whole range of actions that they object to now could be brought in that forum. So they should do it there. Nor in any event would the administrative bodies have the last word. They could always appeal these things. But here, they presented no irreparable harm that they or their members are imminently likely to suffer beyond the hypothetical future dissolution of USAID. And it is not clear why the speed of proceedings in the relevant agencies would be insufficient to address the only actions that have already happened or presently ripe for review. You've got administrative leave, expedited evacuations, change in working conditions. You can handle those in the other avenues. Now, in second, and for similar reasons, the judge continues, their challenges to the government's actions are not wholly collateral, meaning they're kind of secondary. The consideration is related to judicial review. Now, they say based on their allegations of irreparable harm, this point seek the cessation of certain employment conditions affecting their members. Proceedings in any one of these agencies, MSBP, FLRA, FSGB, FSLRB, could all culminate in some sort of relief. They say that we can't go there. We're going to be harmed. But that doesn't square with their motion. They say that there are irreparable injuries. We haven't identified any, so they can go over there. They also say that they're bringing claims within the scope of the agencies. Here, even if the farthest reaches of their lawsuit involve some separation of powers issue, puts that in quotes, and whether a statute or the Constitution has authorized the president to act in a particular way, the preliminary questions this lawsuit poses are employment related, and they should go handle them there. Agency adjudicators could moot their constitutional and APA claims entirely by ruling in their favor and could alleviate those concerns. If they are entitled to that, they can go there to get it. Now, in sum, it appears likely that the claims made by the unions in seeking this injunction are clearly within the schemes that Congress created to solve these claims. That is almost certainly true of their claims about placement of their members on administrative leave, expedited recall, and more. These are changes in employment conditions. These are not the country's melting down. And it may well be true of their claims about the funding freeze, and it could come back down. There could be harms, but all these things have been mitigated. They're even covering living expenses. In sum, because the court also lacks jurisdiction over their claims, they have not established a likelihood of success, just losing at every turn. When also here, we have to balance the hardships and the public interest. You kind of balance the equities, the final two elements, and the public interest. They're not demonstrating, these USAID folks, irreparable harm or a likelihood of success. We don't even have to look at the other factors. But it's worth noting, the record now indicates that those factors, at the very least, do not decidedly tip in their favor. They say, right, again, whining, harsh consequences will ensue if this pause is permitted. Abroad, they say that there's going to be catastrophic humanitarian consequences. Okay, just big babies constantly using this language. It undermines their arguments. The judge doesn't buy it. They came at the initial stage, told them that catastrophic, we're going to die. Government gives them some more information. Not true at all. Saying that they cannot continue to administer their programs. Now at home, they point to the already discussed harms. They say this is a globally critical agency, blah, blah, blah. Now the court recognizes the potential consequences of the government's actions, but the government has also identified plausible harms that could ensue if the USAID are not permitted to resume. Saying in the president's view, the U.S. foreign aid industry is not aligned with the American interests or world peace. So the government is undertaking a review, and it's determined the best way to do the review is to pause a substantial portion of the funds. According to the government, if you interfere with this pencils down approach, that would prevent the USAID from actually auditing things the way they need to audit them. So the judge says, look, weighing the union's assertions to the government's is like comparing apples to oranges. One side claims USAID operations are essential to human flourishing, right? It's so pathetic. You have to have us or humanity is going to stagnate and we're all going to atrophy and die. And the other side claims that they're presently at odds with it. It's simply not possible for the court to conclude. I don't know. Maybe you guys are doing good stuff, maybe you're not. Or whether the public interest favors or disfavors an injunction, he kind of punts. But because they haven't carried their burden as to the other two matters, and because the government has at least made a colorable case that these are essential to our policy goals, the final two factors are not in tension with denying you this injunction. And so, for the reasons explained above, the court concludes that these USAID unions and all these employees have not demonstrated that they or their members will suffer irreparable injury, absent my injunction, that their claims are likely to succeed on the merit, not going to happen, or that the balance of the hardships favor an injunction here. And so, big victory. The court will accordingly deny the union's motion for a preliminary injunction and will dissolve its previously issued temporary restraining order. Boom. So that's how it should have been from the very beginning. Okay, that is a real reasoned decision. Thank you, Carl J. Nichols, for that. Obviously, their catastrophic human flourishing nonsense was nonsense. Judge bought it at the outset, but the record has been corrected. So this is a big victory, and we're starting to stack these up here, which is good news, right? Because a lot of these claims are very much the same. In the same vein, this came out of the District of Columbia, and it's these people have essentially no standing, and it's not the official, holding. It's like they're not meeting the elements of even the TRO or any any of the elements to secure the preliminary injunction. It's the same arguments, as we'll see.
We're now hearing from constituents in some traditionally red districts right now complaining about what they say is the chainsaw approach and saying that it's been done very sloppily, the cuts to jobs and spending. How do you respond to that criticism?
I love how the media takes a few critics when the overwhelming response from the American people is support for what this administration is doing. If you look at the public polling, 70% of Americans, according to CBS, believe that President Trump is delivering on the promises he made. There should be no secret about the fact that this administration is committed to cutting waste, fraud, and abuse. The president campaigned on that promise. Americans elected him on that promise, and he's actually delivering on it. And this is something that Democrats promised they would do for decades. President Trump is just the first president to get it done.
Let me ask you about the fraud, if I can. We can all have our own opinion about what is wasteful spending, and Republicans have praised the president for cutting wasteful spending, but fraud, of course, is a crime. So have you turned over evidence of fraud to the Justice Department, and when should we expect to see those indictments?
It's a clever question. First of all, I think all Americans would agree that funding mastectomies in Mozambique is not something that the American people should be funding, or DEI programs. I think it's fraudulent that the American government has been ripping off taxpayers in this way. And we also do know there has been extensive fraud, particularly if you look at Social Security. In fact, according to an IG report from the Social Security Administration, there was $71 billion worth of fraud in one single fiscal year that we know about. And so that is a lot of fraud, Peter. The government has admitted to. So this administration is committed to finding even more of that fraud, waste, and abuse.
To be clear, that $71 billion was from 2015 to 2022, so it wasn't in just 1 year. And it was
$71 billion.
But it wasn't in 1 year, just to be clear.
In one report.
And it was in one report over multiple years, from 2015 to 2022.
So are you defending $71 billion in fraud, Peter? That's a lot of money.
Yes, he is.
Far too much, and that's why this administration... Why is the media so against cutting waste, fraud, and abuse from the government? I don't get it.
They're in on the grip.
We won't be deterred from people like you and the press who are clearly adamantly opposed to cutting waste, fraud, and abuse, but we know that American taxpayers at home who have been struggling with an inflationary crisis don't want their tax dollars going towards crazy DEI programs in countries overseas. They also don't like the fact that there has been $71 billion worth of fraud in Social Security and improper payments going out the door. That's a problem that needs to be fixed, and President Trump is going to fix it. That's your fifth question. Elena, do you have anything to ask?
Because you said something that wasn't true, which is you said that they have found before that they believe there have been tens of millions of people who are receiving money who are dead on the Social Security list. The same report that you referred to said that almost none of those individuals are receiving
Peter, did you watch the full clip of the interview that I did when I said that? And I said there are a lot of unanswered questions, and we suspect there could be tens of millions of people.
I'm saying the IG report
so you just said what I said is not true. In fact, it was true. That's a suspicion that this administration has, and we're committed to finding out the truth. Thank you, everybody.
Peter, stop your lying. I don't think that was Peter Ducey. I think that was some other dude from some other crap network. But he, of course, wanted answers. He got them. Pam Bondi asks a very good question of the media. Why are they so into fraud and waste and abuse? And you can see where the media is going with this. They want, like, well, you keep saying fraud. Like, under what U.S. code, what title, what statute are you going to charge them with? That's not exactly what we're talking about. Fraud can be that, can reach the level of criminality, but it can certainly be under fraudulent pretenses. Yeah, this is going to be an American interest to go circumcise the Sub-Sahara. All right. You have to explain that to us, but I think there's other higher priority items that are more in America's national interest and deliver a much higher return on investment for our people who are funding all of it in the first place. So shout out to Caroline Levitt. Amazing job responding back to the media.